Advocate Maughan and Downer and journalist Karyn Maughan have won their application to set aside the private prosecution bid instituted by former President Jacob Zuma at the Pietermaritzburg High Court. Maughan and Downer were asking the court to set aside the private prosecution and also for an interdict to prevent Zuma from pressing charges against them in future. Downer and Maughan both contend that Zuma's medical documents were part of a public court record before they were published in the media. For more on this, our reporter Simphiwe Makhanya spoke earlier on to Mpumelelo Zikalala, who is an attorney at Zikalala Attorneys.
It basically means that the applicants in this matter, which is Advocate Maughan Downer and Ms. Karyn Maughan, have been successful in setting aside the validity of the summons or the private prosecution that was instituted by the former president. Now, not only that, the former president has been interdicted from taking any further action based on the summons that have been issued earlier. And in addition, in terms of the cost, they've been awarded the highest cost order that you can be able to find in this type of proceedings, which is the client and owner attorney's cost order, which is basically the highest that there is. Now, it gives an indication of the thinking of the court in terms of saying the type of matter in which you've engaged in, we need to punish you a bit in terms of the cost and make sure that we're able to send a message out there to say that don't engage in this type of applications. And then looking at it from another perspective, it basically means that on the agency, the court found in favor of the applicants by saying that this was an urgent matter that had to be heard on an urgent basis. Secondly, on the merits of the matter, then they seem to believe what they have stated in their papers of saying that the matter has got ulterior motives in terms of the summons that have been issued and all the other things that are part and parcel of that. When I glanced through the judgment, which was very briefly, there is mention of that private prosecution certificate which is not suspect specific, which then says it does not include the name of Ms. Karyn Maughan, hence it can't be taken as if it included them. Now, there's going to take a bearing on the matter which is also taking place in Gauteng, in which the current president, Mr. Ramaphosa, is being prosecuted. If the thinking of the court is around the same lines, also bearing in mind that it's not the same court in which those matters are sitting in, but it does give an indication of how the interpretation of the type of or the manner in which the null prosecution certificate should be drafted is perceived or viewed by the court. But in short, Advocate Maughan Downer and Ms. Karyn Maughan have been successful in their bid. There are no summons which they are currently facing. There's no private prosecution that they're currently facing, and they can expect to be paid by the cost of them engaging in these processes on the higher scale, which is the attaining on-client cost.
Legally speaking now, where to for the former president in terms of this judgment?
Either accept it or secondly file a leave to appeal in this honorable court in front of these three judges and say to them, we so believe that a court which is higher than yours, which is the SA, will find differently. Please grant us leave for us to go to the SA. There are pertinent matters in which you have found maybe some inconsistencies if there are, or maybe the different interpretation of the law if the SA would able to get to that interpretation. So allow us to go there and let the SA decide this matter. If the judges say no, then you can petition the SA and say to them, I've tried your learned brothers and sisters. They have said no, but I so believe that I have a matter in which you must then be able to decide. As stated earlier, this is new territory. There aren't many cases that have dealt with the definition or the proper tabling of null prosecution certificate, the manner in which private prosecution ought to be administered. So certainly there would be an interest for an SAA judgment and even a constitutional court judgment so that we allay the matters and we're able to finalize what is the legal position when it comes to null prosecution certificates, private prosecutions, when can it be instituted or not instituted, instances in which the civil court will have jurisdiction or would want to pronounce on a matter that is currently taking place within a criminal court.
If the former president does in fact appeal this judgment, will that have any bearing in terms of the criminal matter that is before this court?
Not at all. Remember, these are two parallel processes. They may be intertwined in terms of the parties or the role players that are there, and in certain instances the facts are linked one to the other, but it does not stop any of the two matters from going on simultaneously. It simply means that once a leave to appeal has been instituted, you go back to the stage in which you were in a few moments ago. So there will be a summons that will be issued. There will be a criminal matter which is supposed to take place up until there's a higher court that has decided whether it wants to uphold this particular judgment or to dismiss it.